Hello everyone and welcome to video 3.2.9 for the Legal Studies guy. A few technical difficulties today, so there's no head in the corner, just going to be audio only, which I'm sure will keep plenty of you happy. But yeah, we'll hopefully have the webcam working for future videos. Quick quote today from the author Stephen King. Really like this one in terms of a lot of you early in term 2 now or just in holidays watching this. And yeah, amateurs sit and wait for inspiration. The rest of us just get up and go to work. And I think that's a really important thing to look at in terms of your approach to Year 12, but also in your future endeavours, is that, you know what, you're not always going to feel inspired. And if you just sit around waiting for that bolt of inspiration to hit you to actually start doing something, then the reality is you're going to rarely get up and actually do the work. And yeah, 9/10 of life is just showing up, and that's the crux of it. Just actually getting up and doing it is going to get you much further than sitting around waiting for that moment of inspiration and that moment of energy that might never come. So we are at video 3.2.9 today. Now you'll note, if you're following along in the year these are being released, that this is being released straight after video 3.2.4. And if you're a student in my class, you'll be doing these videos in that order. That's because I think there's a really... it's really important that we understand the distinction between methods of dispute resolution and institutions that resolve disputes. Methods was our last video, looking at mediation, conciliation, and arbitration. And then this video that we're doing now is looking at institutions that resolve disputes. So the purposes and appropriateness of institutions used to resolve disputes, including Consumer Affairs Victoria, the Victorian Civil and Administrative Tribunal, which we colloquially refer to as VCAT, and the courts. Now, why this order is important, I think, is because if we went through and started doing, the next dot points in the sequence, we'd be looking at things like class actions, the role of different personnel in a civil dispute, and particularly looking with a focus on, the judge, the magistrate, if a jury is used. And we'd actually have quite a heavy focus on courts resolving disputes. I think it's really beneficial to first look at, okay, we've considered that you can resolve disputes using methods such as mediation, conciliation, arbitration, as well as, a more formal binding method such as a VCAT hearing or a trial. Now we should also look at the different bodies or institutions that actually offer those different services to help you resolve a dispute. And then we'll get into a bit more of the nitty-gritty around how the courts themselves actually work. This key skill, 326, is a discuss skill, and it's the same one we looked at in that last methods video. Discuss the appropriateness of, and not class actions and not methods here, discuss the appropriateness of institutions used to resolve a civil dispute. So we're going to look at Consumer Affairs Victoria, VCAT, and the courts, and we're going to look at effectively what kind of disputes they're best placed to resolve, what kind of disputes they are the most appropriate for, versus what kind of disputes they're not appropriate for. And hopefully at the end of it, you'll be really rock solid on this concept of what institutions out there exist to help you resolve a civil dispute if you have one. So, CAV, VCAT, and the courts. Now, this is the only slide where I'll actually give you some information about what they are. If you want to get a bit more of that background info just into what CAV and what VCAT are as bodies and what they do at a base level, that more initial introductory knowledge, go to their websites. I can't stress that enough. They've got really comprehensive and solid websites. Go and check those out. Learn a bit more about what the bodies are, because I really want the bulk of this video to focus on that concept of appropriateness. So when are they actually going to be used? What type of disputes are we going to use them for? So we're not actually spending too much time on what they are. I would also highlight that I do have another video that I filmed a few years ago that deep dives into CAV and VCAT in a lot more detail and actually takes you through using their websites and how you would use their websites to get support to resolve a dispute. I would really recommend that after you watch this one, you watch that one, because that's going to give you some absolute gold information to help you put into answers and then on an exam. So, with all that introductory explanation out of the road, what are these three bodies? So, Consumer Affairs Victoria is the first one that we're going to look at. You might have looked at this in Year 11 if you did Year 11 Legal Studies. Consumer Affairs Victoria is an organisation, a legislated body set up by the government, and its primary role is to make sure that businesses comply with consumer law. So, Consumer Affairs Victoria, it's all in the name. It's about making sure that businesses are complying with consumer law, that businesses are not ripping people off, that businesses are making sure that customers have their rights upheld in consumer matters. This is, there's a range of things that CAV does in this space. There's education. They can actually do some work around taking businesses to court if there's a pattern of ongoing behaviour in terms of breaching the consumer law. They can ultimately try and get sanctions enforced on businesses. Perhaps you play for a local football club, netball club, cricket club that's an incorporated entity. Consumer Affairs Victoria looks after those, so your club secretary, president, etc. would have to report to CAV about effectively what your club is doing, because CAV looks after that. So they have these a really, really broad range of jobs that they undertake, broadly centered around this idea that making sure that businesses and corporations are complying with consumer law and corporations law. And as part of this is why I'm really harping on this, they provide limited conciliation services. So we're looking at institutions that resolve civil disputes. CAV does support the resolution of certain civil disputes, but only in a very limited manner. And that's going to come up later when we talk about appropriateness. So CAV provides limited conciliation services for consumers and tenants in disputes that they have with businesses or landlords. Really, really important to note that you cannot go to CAV if you have a dispute with a consumer if you are a business. You cannot go to CAV if you have a dispute with a tenant if you are a landlord. CAV is only available to access and seek support and seek some of this support with conciliation if you are that consumer, if you are in a way the party with the least amount of power. Participation in the services, the conciliation services that CAV offer is voluntary for both parties. So you could feel you're ripped off by a business, you could seek support from CAV, the business could refuse, nothing more that CAV can do. So that's a really, really important point when we get into their appropriateness. Effectively, what CAV offers is, if you have an issue with a business and you approach them and you go through the process, and there's a few things you have to do first, like you have to try and resolve it with the business yourself, you have to provide evidence that you've done that. Ultimately, what CAV is hoping will happen is you'll speak to them, you'll explain your issue, and then they'll speak to the business and they'll act as like that mediator, I should say conciliator in this case, but they'll act as that impartial third party who kind of stands between the two of you, gets your version, talks to the business, gets their version. And where it becomes conciliation is that obviously conciliation means the conciliator can offer suggestions. Because CAV are experts in consumer law, the whole idea is that they can advise you and they can advise the business on what the law is. And they can realistically suggest to the business, hey, based on consumer law, these are the things that you should do. The business does not have to do them. It is voluntary. It is not binding, and the business cannot be forced to participate, and the business cannot be forced to follow the suggestions of CAV. And that's where you ultimately might need to involve another dispute resolution institution. So, key thing with CAV, limited conciliation services for consumers and tenants, voluntary. If you try to use CAV and the voluntary service does not work, you then perhaps might need to involve a body like VCAT. Now, VCAT, as we saw in that opening slide, stands for the Victorian Civil and Administrative Tribunal. And VCAT was set up a number of years ago. I couldn't tell you exactly when. I think it was in the 90s, but that could very much be wrong. As an amalgamation of a bunch of different tribunals that existed. So there are all these different tribunals that existed to deal with, hey, this tribunal deals with residential tenancy disputes, and this tribunal deals with building contract disputes, and this one deals with planning disputes between councils and developers, and this one deals, so on and so forth. And they all kind of ran their own thing, and they all kind of ran their own ships and had their own bureaucracy and, cost taxpayers X amount of money, whatever it was. And the decision was made that the best thing to do would be to take all of these different tribunals and put them into the one organisation and one entity, and have effectively one bureaucracy run it. So the Victorian Civil and Administrative Tribunal was created out of that. And as a result, because it's an amalgamation of all of these different tribunals, it is a dispute resolution body that can hear a broad range of civil and administrative matters. This is a really important already comparison or contrast with Consumer Affairs Victoria. Consumer Affairs Victoria can only provide limited conciliation services for consumer matters, whereas VCAT can hear a broad range of civil and administrative matters. And the whole idea is that through VCAT existing, it's an alternative to going to court. So you can take your consumer law matter that CAV couldn't perhaps help you with, or you didn't bother going to CAV, you could take it to VCAT instead of taking it to court. Your residential tenancy issue, you can't get your bond back perhaps, or your landlord's trying to charge you for some repairs, or your landlord's refusing to repair something. You don't have to take that to court. You can take it to VCAT instead. You feel like you've been discriminated against, you can take it to VCAT instead of taking it to court. The whole idea of this is that by offering tribunals that are less formal and more flexible than a court, there'll be less barriers for people to access civil dispute resolution, such as cost particularly. The fact that VCAT has more flexibility means they can use perhaps they don't use a wider range of methods than the courts, but they can work with more flexibility and use all of the different methods available to them to try and resolve disputes. And they do have the ability, unlike CAV, to compel parties to participate. So they can force the other party to be involved, and if the other party doesn't, they can make a decision without them. So VCAT's very much like, I want to make this really clear, like with methods, how I talked about how mediation can actually be great for really complex matters. VCAT often deals with really, really high monetary value matters. It does a lot of planning stuff. So it'll be dealing with, whether, a council should or shouldn't approve, tens of millions of dollars worth of, apartment complexes and things like that under their planning laws. So VCAT deals with incredibly complex civil disputes. But they're also great. One of their the point I'm trying to make is one of the really great benefits of having VCAT is that it exists for the people who have disputes worth a few $100s or disputes worth $1,000. We're taking that matter to where that's an important amount of money or an important dispute for an individual. But taking that matter to court is simply not possible. Like, it's not cost effective. People can't afford that. People can't deal with the time that that's going to take. VCAT is then a great alternative to deal with those matters. So that's not saying, like I said, that's not saying that VCAT can't deal with really high value complex matters, because they do, and they're really good at that as well. But one of the great benefits is that by being less formal, being more flexible, VCAT's then usually lower cost for parties, which is really, really important. Finally, we have courts. We should all know what courts are. Don't need to dwell on this too much. You'll see a real leveling up again in terms of courts are able to hear all civil matters. So courts effectively have jurisdiction over any area of civil law. Higher level of formality, we will learn in later videos, but have already learned with criminal law, and obviously through watching a lot of TV, I imagine that, there's robes, there's judges sitting up high, everyone faces in certain directions, there's really heavily enforced rules around evidence, the procedure that's followed. So there's this higher level of formality in court that usually comes with a higher level of cost, because as a result you're needing to use lawyers and the such, and an increased cost of filing fees and those sorts of things. Courts still do utilise a wide range of methods to resolve civil disputes. That's really important to understand, that courts use mediation, courts use conciliation and arbitration, but ultimately it can result or finish with a trial or a hearing with strict rules where a binding decision is made after both parties have had a chance to present their evidence. So yes, courts do use other methods, but ultimately it can end in that binding decision, which VCAT can as well. But yeah, really important point is these first ones. CAV really limited, VCAT really broad jurisdiction, and then courts can hear every civil matter. You can pause this video and copy this down. This is just highlighting that institutions are different to methods. Again, can't stress that enough. So pointing out that an institution like VCAT will use multiple methods to resolve disputes. So VCAT might send your dispute to mediation, where you're trying to get an agreement between the parties. VCAT might use case conferencing, which is where the VCAT member who's hearing the dispute actually meets with both parties and maybe offers suggestions on resolution, where you're again hoping to get an agreement between the parties, like conciliation. VCAT has a special method. It's not arbitration, a method called a VCAT hearing, which is the culmination of the VCAT process, where a VCAT member can hand down a legally binding order, much like a magistrate can, or a judge can, in a civil hearing, civil trial. And VCAT also offers a special method called fast track mediation and hearing. Bit of info there, but I'd recommend having a look at that one and looking at VCAT's website to learn more about that. CAV only uses one method. They only use conciliation, so a conciliatory approach where we're looking for an agreement between the parties. And as I stressed earlier, if one party refuses, then there's nothing CAV can do, and there's nothing you can do if you've initiated or spoken to them about support with a claim. And finally, pardon me, and finally you've got the courts themselves as an institution, and they are similar to VCAT in that they will use mediation, case conferences, they'll use arbitration in some circumstances, refer cases off to arbitration, but they'll also do, ultimately, a little bit like a VCAT hearing, but even more formal, they'll do things like a trial at the end, or a hearing where a magistrate hands down a legally binding decision. Courts are really heavy users of mediation. I want to stress that. Courts will very regularly refer matters to compulsory mediation to try and get it resolved before it has to take up the time of having a trial. Final point I would make, on the institutions front before we talk about their appropriateness is, these are not the only three institutions that exist to resolve civil disputes. That is, or can be, a common misconception that you've got to use one of these three. there are other bodies out there. There's the Dispute Settlement Centre in Victoria that offers free mediation. There's the Melbourne Arbitration Centre, which offers arbitration services. And there's ways of resolving civil disputes that don't even require a formal institution to support you. There's knocking on your neighbour's door to have a conversation with them about the fence that they've been refusing to pay for. There's exchanging letters, letters written by your lawyers. So there are many different ways to resolve civil disputes. It doesn't have to be these three. You can go to the Ombudsman for support with certain things. But these are the three that are listed in the study design, so the three that we are focusing on. So I like, when we talk about appropriateness for these institutions, I like to look at it in 5 categories of appropriateness. More or less, eligibility or jurisdiction. Can that institution, 1, 2, or 3, can it actually resolve the dispute? Because there's no point going to Consumer Affairs Victoria. You can't go to Consumer Affairs Victoria if you've got a defamation matter. It just can't resolve that dispute. There's no point going to Consumer Affairs Victoria if you've got a family law matter. If you've got a residential tenancies issue, though, you can. So the first factor that's going to affect appropriateness of one of these institutions is, can it actually resolve the dispute? And this is where it's important. I've got some key terms here. Consumer Affairs Victoria has a really limited jurisdiction, and we know that it is only consumer or tenancy disputes. VCAT's jurisdiction is more broad. It can hear most civil matters. Residential tenancy, discrimination, consumer building planning, deals with pretty much anything you can think of outside of personal injury, defamation, or family law. And defamation and personal injury are the sort that occasionally come up on exams. And that's where it's worthwhile knowing. You don't need to... And examiners aren't going to be incredibly harsh on this. There's not an expectation that you've sat down and studied VCAT's lists to understand exactly what it can and can't hear. But it is worthwhile having that broad understanding of there are a few things that it can't hear, as opposed to the courts who can hear all civil matters. Again, examiners aren't going to be incredibly harsh on you. There's a question I've got that I'll show you shortly that is a civil dispute that VCAT doesn't actually have jurisdiction over, technically. That Consumer Affairs Victoria doesn't have jurisdiction over. But there was certainly no... students weren't going to be negatively marked for not clearly knowing that. They were expected to more look at the factors of the features of the dispute. So important that you know that it's not absolutely necessary to be, keeping detailed notes on what they can and can't hear, as long as you know broadly that Consumer Affairs Victoria is limited, VCAT is broad, and then courts is everything. Once you've considered whether the institution can hear the dispute, the next thing I think that's worthwhile understanding is then the cost of each of these places. And again, they level up here. So this is why it's important, or it's good to look at it through this table and watch how they level up. Consumer Affairs Victoria is free. Whilst there's limited eligibility to resolve a dispute through CAV, it doesn't cost you a cent. Okay? So that's a really, really good... Think about the sort of maybe case studies you'll get on an exam. It's a really, really good feature to know. Hey, this person has this issue. They're a tenant. Sounds like they're maybe they're young, they're having some financial issues. CAV would be really appropriate because they're free. This is as opposed to VCAT that's not free but is low cost comparatively to the courts. And sometimes can be free if you have a concession card in certain lists. VCAT has different fees for all of its different lists, but they are one-off fees. So Unlike courts where you pay ongoing fees and you have to pay basically an itemised list of fees, a fee for mediation, a fee for every page of photocopying, a fee for every document that you file. VCAT, you just pay one fee, and that is what gets your dispute resolved. Every single list has its own fees at VCAT, and the fees are in a 3-tier structure, which is concession card holders or, so students, etc. They'll pay one rate that in some matters is free, but is always generally low. Then there's an everyday person or normal person rate, effectively. And then there's a corporations rate, which is more expensive. So anyone who is a business or a company initiating something through VCAT, they have to pay a higher rate. And the other thing with VCAT to know is that in some lists, not expected to know which ones, but in some lists, like for example, consumer matters under $15,000, I think is one of them, legal representation is prohibited. So you're not allowed to have it, which lowers the cost. Maybe makes it more accessible or makes it more appropriate for matters where people maybe don't have a lot of money. And courts, we know already, harp on this a lot, courts are very expensive. You need lawyers and there's ongoing fees. So that's going to help you understand their appropriateness. The next one is to think about time. And again, they're going to level up. Consumer affairs quicker, VCAT quicker, courts slower. So courts are slow because they have long pre-trial processes, there's regular delays, there's a heavy load on the courts. That increased level of formality, particularly the pre-trial process, the exchange of documents, etc., the affidavit of documents, the exchange of evidence through discovery takes a really, really long time. As opposed to VCAT, where some lists, particularly like urgent residential tenancies matters, etc., they'll be heard within weeks, sometimes within days. So VCAT, much, much better for certain matters that need a quick resolution. And generally speaking, VCAT will resolve things quicker than the courts. Although VCAT is becoming more and more popular, it's having an increasing caseload all the time, which means those delays are getting longer. And that's a really good point you can put in answers for VCAT. You can argue that VCAT's quicker and give reasons why, but you can then also counter that and say, hey, there's a lot of evidence lately that VCAT's actually having increased delays. If you just Google that, like Google VCAT delays, you'll probably get a bunch of articles about how their caseload has increased, and as a result, there's long waiting times. Because Consumer Affairs Victoria is encouraging parties to resolve the dispute themselves through a cooperative process much quicker. Yes, you can't get a binding resolution, but you can get the dispute resolved much quicker if both parties are willing to engage or the other party is willing to engage. Then we might start thinking about the formality of each of these institutions. And again, it's going to level up. CAV, really low formality cooperative process, can't compel the parties. Low medium at VCAT, yes, there are some, you might end up at a VCAT hearing. VCAT hearings do have rules, but they are more relaxed. And there's no hard and fast set of rules for VCAT hearings. Apparently every VCAT member might run things slightly different. It's a bit like the Wild West. But there is some level of formality. It is a hearing with evidence and I guess arguments being put forward, and binding decisions can be made, but there is that increased flexibility and an increased use of things like mediation. So VCAT has that lower level of formality still, but probably higher than CAV, so low medium. And then courts, we know, have a really, really high level of formality with those strict rules of evidence and procedure. So again, leveling up from CAV through VCAT through to the courts. And finally, the outcome. So what are we getting at the end? And you might have a dispute where it clearly says, often in exams, they'll give you a case study and it'll clearly say that one party's refusing to say, answer the calls of the other party, or one party's refusing to do something. Pretty much straight away, that means you can cancel out CAV. Because it's non-binding, it's agreement-based. If one party is refusing to engage, then CAV is useless. That's as opposed to VCAT, that actually can hand down a binding order without you there. So if you refuse to turn up to VCAT, VCAT will just rule without you there. And on the balance of probabilities in a civil dispute, if you don't turn up, you are going to lose. Someone's going to present evidence generally to meet that standard. They're going to have the burden. You're not going to be there to throw any doubt or defend yourself. As a result, you're likely to lose the matter. And VCAT's decisions are binding at hearings. And finally, courts hand down binding resolutions as well. And again, a reminder that even if something is resolved through mediation, it's likely that that will be made binding through a deed of settlement or similar. So that's actually a lot of what we've done in that last slide is the skill. So discussing the appropriateness of, again, scrub these ones out, of institutions used to resolve civil disputes. Again, go over this a lot, but we know a discussion is an exchange of opinions. So it means both appropriate but also not appropriate. So when will they not work for a dispute? And this is the sample question that I just put out there for you. Got a statement. The Victorian Civil and Administrative Tribunal, VCAT, is a more appropriate body than Consumer Affairs Victoria to resolve this dispute. Discuss the extent to which you agree with this statement and justify your response. So basically, straight up, VCAT is better than CAV. Discuss. So you need to be both putting forward reasons why VCAT is better, but also considering the exchange of opinions, considering this statement might be wrong, and considering reasons why CAV might be better. And then this was the case study that question was attached to. Now look how extensive this is. Danny and Sonny contacted a builder, build them a new house, this contract under the Domestic Building Contracts Act, range of defects, they want to move in, but they've tried conciliation, so many points in here, that it's really, really actually challenging to try and figure out what to pick out and put into an answer. But thinking about, again, working through our list. Okay, starting with jurisdiction eligibility. Let's think about this. VCAT, it's effectively a building dispute, maybe consumer because they've entered into a contract with the builder, I guess. Contracts, that broadly fits under VCAT's jurisdiction. Is it in CAV's jurisdiction? Actually, fundamentally, this isn't. But we weren't punished, or people who answered that way in an exam weren't overtly punished, because you could view this, and you guys are just in Year 12 doing legal studies, you could easily view this as a consumer matter, that they have purchased the house and they have entered into a contract and paid for the building of the house, and they have issues with then the fulfillment of that could be fundamentally seen as a consumer matter. So straight away you would be able to go, okay, they kind of both do have jurisdiction. Let's consider the cost. Well, why might CAV be more appropriate here? Well, CAV might be more appropriate because it's free. And Danny and Sonny have just built a house. That's obviously cost them a lot of money. Now they're having a dispute with it. They've actually said they're refusing to pay the rest of what they owe, and they want to move into their new house as soon as possible. So you might start looking at that and go, okay, costs and time, free and quick. CAV could actually be a good resolution body here. So you might start putting into an answer that CAV may be more appropriate due to providing a free service. CAV services come at no cost, as opposed to VCAT, which usually charges a one-off fee. And then, even though I've got some points in this paragraph, I should point out that none of these paragraphs are, or none of these points are fundamentally complete, because they don't have those, or none of them have those stimulus connections. You would then be looking to add to this paragraph, in this instance, because Danny and Sonny are looking for or because they've just spent a lot of money building a house, they may be looking for a dispute resolution model or institution that is free. However, you'll see I've got here, VCAT is more appropriate due to the outcome reached. So outcome, and we know that VCAT offers a binding resolution, whereas CAV doesn't. VCAT is able to hand down binding orders through a hearing as opposed to CAV requiring parties to come to a voluntary agreement. And you could say, in this instance, the builder has continued to ignore the report and insist there are no defects. So the builder has continually refused, and as a result, a non-binding body like CAV would not be appropriate as opposed to VCAT that can force the builder to comply or can force the builder to both engage and then follow through on fixing the defects if that's the finding that they make. So really, really important to make sure you're making those stimulus links. And that first paragraph I've got here is just talking about the formality of VCAT. Whilst it operates using more relaxed rules, VCAT is still able to compel parties to participate. CAV is not able to. So connecting again to that same point that I'm making at the end around binding orders and then connecting that into the stimulus. So this is the bones of a really strong answer to that question because you're looking at both sides, you're considering both how CAV may be more appropriate, but also why VCAT is more appropriate. If you make those stimulus connections and make a strong argument at the end about which side or the extent to which you agree with the statement, that would be a really, really strong response to a discuss the extent question. Been a long video, so I won't harp on the principles of justice too long. Just got a few things in here that you can pause and add to any table that you're keeping track of. Look, ultimately, every institution is stacked with people who are experts. VCAT lists are run by people who have practical experience in those industries and spaces, so we're likely to therefore get the right decision or the just decision. There's a lot of access points here. It's all about cost-effective, multiple avenues for dispute resolution, reducing barriers that people face. So VCAT, CAV all help with access, and then it helps access through the courts by reducing delays. But yeah, VCAT's increasing caseload and VCAT's increasing costs maybe go against that. And then some stuff inequality around the prohibiting of legal representation. But also that, different or similar legal disputes could go to different institutions and be resolved in different ways, which could be argued as being a lack of equality. Can't, again, like I said it earlier, just go to their websites. Have a look around, look at initiating a dispute, look at the different lists for VCAT. You will learn so much by doing that. And also watch that other video that we've done on these as well, because that will really, again, help you understand what sort of dispute is, or the strengths of these two bodies for resolving the sort of disputes that might end up being on an exam. Ultimately, hopefully, if someone said to you now, hey, having a real bit of trouble with this, like bought this, laptop the other day, not working, the business is saying this to me, I don't know what to do, you can be like, hey, I already know 3 institutions that can help you. You've got a consumer matter. You've got Consumer Affairs Victoria that does this, you've got VCAT that does this, or you've got courts that do this. And that person can then hopefully walk away and know exactly what institution is appropriate for their dispute. And if you can do that, you can therefore answer our essential question. As always, feel free to leave any feedback below. Thanks for making it through a long video. And yeah, we'll be talking to you about 3.2.5 very soon.